Hi, this is Tom Azoni. I'm with Secrest, Wardle, and today's seminar involves updates to the open and obvious hazard chapter that I prepared for our premises handbook. Today I want to talk with you about appellate cases that came down in 2017. And I have to say at the outset that 2017 was not a hot year for this area of law. There were a few interesting cases that were decided that we'll discuss today. But in general, the key principles that we've gone over in past seminars have all been preserved by the appellate courts. And the good news is that the defense is winning the bulk of these cases, both in the trial court and in the appellate courts. So I always love this first photograph, and I use it time and time again because it really depicts all of the key principles that you need to know in this area of law. This porch, as I've told you before, belonged to one of my partners, and he was having a new porch installed. And this is how it was a couple of days into the project. You'll note at the bottom, he had security tape around warning people to stay away. Clearly, the porch is in disrepair, and it's be quite dangerous to anyone that tried to encounter it. But if you look closely at the door handle on the front door, you'll see that somebody managed to leave a coupon or a flyer on his door, and that person is your plaintiff. If someone were to get hurt climbing onto that porch to reach that door handle or climbing down and was injured, you would have as a defense to that claim the open and obvious hazard rule. And from this photograph, what you can tell are all the principles that you need to know. First, the property involves a condition of the land. So in order for the open and obvious hazard rule to apply, the cause of action has to arise out of a condition of the land. And it's not just the dirt that makes up the land, but it's anything that's permanently attached to the property. So we have the porch qualifies. And then secondly, when that case is brought, the question to be asked is whether or not a reasonably careful person would have been able to see and avoid that hazard. And here, this is a classic example. If this accident occurred in broad daylight, especially, no one in their right mind would approach that condition unless you were accepting all of the risks associated with it. And so the motion would be brought in on behalf of the defendant, and quite certainly the case would be over. And note, please, that in analyzing the facts of this hypothetical case, we never need to consider whether the warning tape was an adequate warning, whether the homeowner should have done more to protect business invitees, whether that tape was sufficient. All those questions become irrelevant when the court rules that the defendant owed no duty of care to the plaintiff. Because if no duty of care exists, then the case is over. All right, so I want to move on to cases that were decided in the last year. And the first involves the landlord and tenant area. And this is a topic worth reviewing, and several appellate cases have considered this area of law. Here's what you need to know. First, if your insured is a landlord in a residential setting, not a commercial lease, but a residential setting, then the Michigan Landlord-Tenant Act creates duties of care that have nothing to do with negligence, but will result in a verdict for the plaintiff if the elements of the cause of action are proven. So let's read it. So this is the statute here. I put it up on the screen, and the key portion is this. It says in every lease or license of residential premises, the landlord, the lessor, promises that all of the common areas are fit for the use intended by the parties, and B, to keep the premises in reasonable repair. But it's that subparagraph A, that first phrase, that creates the bulk of the causes of action in Michigan, particularly so with respect to snow and ice conditions. The key to this cause of action is the phrase fit for the use intended by the parties. Why are we talking about this in the context of open and obvious hazards? And the reason is because plaintiffs typically bring suit asserting both common law theories of negligence or gross negligence, as well as a statutory claim under the Act. In Michigan, the open and obvious hazard rule is available in response to claims of brought under the common law, negligence or gross negligence, but it is not available for statutory claims. If the complaint alleges the plaintiff fell on a snow-covered parking lot, your attorney will be able to easily obtain a dismissal of the negligence claims, that is, the common law claims. Recall from last episodes of this seminar that if there are winter conditions going on generally, that is, the weather's cold, there may be snow piled in certain spots, snow flurries are occurring at the time of the fall, winter-like conditions are happening when the plaintiff is injured, then the courts have generally concluded that the plaintiff should have been alert to possible icy conditions and his or her case will fail, even though the particular patch of ice was not apparent to the plaintiff. And that, as you know, is the Kenny versus Katz Funeral Home case. All right, so if a plaintiff brings these two causes of action, alleging a winter snowy condition, the common law claims, you're going to get those dismissed fairly routinely. Now the statutory claims are more difficult, but here's what you need to know. The first thing that's important to know is that only the lessee, that is the tenant, can make a statutory claim. His or her guests may not. So the only claims that a guest of a tenant can make are common law claims of negligence or gross negligence, for which the open and obvious hazard defense will apply. And that case is called Mullen, M-U-L-L-E-N, versus Zerfas, Z-E-R-F-A-S. It's a 2007 Michigan Supreme Court case. All right, so now it's to the second part of that claim, the statutory claim. The plaintiff must prove that the premises were not fit for their intended purpose. And that's the reason the plaintiff fell. That's the contention. Now that sounds like negligence, doesn't it? But the courts have said consistently that the bar for the plaintiff is set higher in these kinds of claims, statutory claims, than in a simple negligence case. And the focus, your focus and your attorney's focus, is to evaluate these things. One, where did the plaintiff fall? That's going to be critically important. I'll tell you why in a second. Two, what's the primary purpose of the thing on which the plaintiff fell? Three, what's the condition of the property at the time the plaintiff fell? And four, was that condition fit for its intended purpose? In saying all this, you should know that even without an available open and obvious hazard defense, landlords are routinely winning these cases brought as statutory claims in both the trial courts and in the appellate courts as well. All right, so let's go on. So here is a really snowy parking lot. I found this picture, and this sort of illustrates the case. So here we have two cases you need to know about in order to have a good understanding of these statutory claims under the Landlord-Tenant Act. You need to know the facts and the holdings of two cases. One, Allison versus AEW Capital Management, which is a 2008 Michigan Supreme Court case. You also need to be able to distinguish it to know the holding and the facts of Hayden, Hayden versus McDermott Apartments, 287 Mishap, 124. It's a 2010 case. So in the Allison case, imagine this parking lot, and imagine it's part of an apartment complex, and the plaintiff, Ms. Allison, needs to get to her car. She walked across a snowy parking lot, tried to reach her car. She testified quite candidly there were at least 2 inches of snow plus ice in the parking lot, and she fell on the way to her car. Now you can imagine if this case were brought as a common law claim of simple negligence or even gross negligence, the open and obvious hazard rule would eliminate that case very handily. But it wasn't brought that way. It was brought as a statutory claim saying that that parking lot was not fit for its intended purpose. The Michigan Supreme Court ruled for the defense and dismissed this case. According to the Supreme Court, as long as the tenant was able to reach his or her car, then the parking lot was fit for the purpose intended. Understand that? As long as the plaintiff was able to get to her car in these conditions, the lot was fit for its intended purpose. Why? Well, the court looked, well, what is the purpose of a parking lot? The answer the court gave is a parking lot is primarily intended to store cars. And if you are able to make it to your car to where it's stored, then the parking lot does not have to be clear of snow. It doesn't have to be in the best possible condition. It just has to be cleaned well enough that you can accomplish the task of reaching your car. And the court looked at the fact that there were footprints in the snow, suggesting that other people had been able to get to their cars. Therefore, Ms. Allison, you should have been able to get to yours. And the rule of that case is that that condition then, the parking lot, was reasonably fit for its intended purpose as a place where cars are stored. And note in that analysis by the Supreme Court, they didn't look to what opportunity the landlord had to clear the parking lot. In other words, they didn't look to see, well, how long had it been since it had snowed? What resources did the landlord have available in order to clear the parking lot? What steps, if any, did the landlord take to clear the parking lot? None of those things were even relevant to the court's analysis. The court only looked at these things. 1, where did the fall occur? Answer, it occurred in a parking lot. 2, what is the primary purpose of a parking lot? Answer, the primary purpose of a parking lot is to store cars. 3, were people able to get to their cars? Yes, there were footprints in the snow. Conclusion, that lot was fit for its intended purpose. So you can see how difficult statutory claims are where the fall occurs in a parking lot. Now, you have to compare next the Hayden case. Remember, I told you there are 2 cases you have to know about. Well, in the Hayden case, the accident didn't occur in a parking lot. The accident occurred on a stairway between levels of the defendant's apartment building. And Ms. Hayden slipped on both snow and ice, and she fractured her left hip. She threw in a claim that there was black ice as well, so snow, ice you could see, ice you couldn't see, darkness. She threw it all into the pot. The Court of Appeals took the same kind of analysis as was taken in the Allison case. They looked at it a bit differently, however. So the first question is, where did the fall occur? Occurred on a stairway, exterior stairway. Well, number 2, what's the purpose of an exterior stairway? The answer is, they said, that the primary purpose or intended use of a stairway is to provide pedestrian access to different levels of a building or structure. Number 3, was there any evidence that other people were negotiating the stairway successfully? Answer, the case facts didn't say, so we don't know the answer to that question. And what the court said was, there's a question of fact in that case, given the purpose of the place where the plaintiff fell, given the purpose of a stairway, that we're going to let a jury decide whether or not the condition was fit for its intended purpose, or the premises were fit for their intended purpose. But in talking about it, the court said some very helpful things for the defense. It says, like a parking lot, the statute does not require perfect maintenance of a stairway. The court said that a stairway doesn't need to be in an ideal condition, nor even in the most accessible condition possible, but rather it needs to simply provide tenants with reasonable access to different building levels. And in looking at it, the court said that reasonable minds could conclude that the presence of black ice on a dark-lit, unsalted stairway aggravated by overflowing ice water from overhead gutters in the presence of freezing rain, wow, what a mess, all could have posed a hidden danger that denied tenants reasonable access to different levels of the apartment building and rendered the stairway unfit for its intended use. So you could see that even in that case, where the plaintiff got her case to a jury, that the court struggled with it and really needed to hear a lot of bad things were going on in order to form a conclusion that a jury question exists concerning that condition. All right, so then other cases that came up in 2017 were similar. So let me just talk with you for a moment about them. In 2017, there was the case of Sandefur versus Mckinley. And in that case, there was snow and ice all along the parking lot, abutting the sidewalk. So in that case, the plaintiff fell on a sidewalk that abutted a parking lot. According to the case facts, Ms. Sandefur took a few steps on the sidewalk, slipped on ice, and then fell to the ground. Now, the court looked at the case the way Allison did and asked the same questions that I posed to you. 1, where did she fall? Answer, she fell on a sidewalk. 2, what is the purpose of the sidewalk? And answering that, the court said that it is a pedestrian walkway. It's intended to allow people to walk from one point to another, unlike a parking lot, which is intended really to drive cars in and out of. But nonetheless, a sidewalk is different in that it is primarily intended for pedestrian use. And then next, was there evidence of other people accomplishing the task of walking along this sidewalk? The answer in this case was they don't know. There was no evidence one way or another on that point. But what the court did find is that the patch of ice was fairly small. And in this case, the Court of Appeals said that Ms. Sandefur could have walked around the patch of ice on the sidewalk, or she could have stepped over it. And in looking at that case, they distinguished an earlier Court of Appeals case in which a plaintiff fell on a sidewalk whose patch of ice was 4 to 5 feet long. In this case, they said it would have been an easy matter for the plaintiff to avoid this hazard, and even though the open and obvious hazard rule doesn't apply, you can sort of hear the echoes of the open and obvious hazard rule in this holding, where they said you should have seen it, you could have avoided it, you could have stepped around it. We're going to conclude here that the sidewalk was fit for its intended purpose. All right. The other case in 2017 involving this area of law is called Shuster versus River Oaks Garden Apartments. In that case, the plaintiff was able to get her case to a jury. Unlike the case a moment ago, Ferguson, where the ice patch was small and the plaintiff was able to step over it if she needed. In the Shuster case, the plaintiff went out into the common areas of her apartment building and testified that everything was coated with ice that morning. There had been no salting during the prior 7 days, and as a result, the court looked at this in terms of the analysis provided in Allison and ruled that there was enough there to get the case to a jury. Basically, in a case where if everything in your apartment complex exterior is coated with ice, there has to be a question as to whether or not the property is fit for its intended purpose. And so that case was one of the rare ones where the plaintiff was successful. All right, so that covers that area of law. The next one, the next cases that came up in 2017 involved plaintiffs pleading around the open and obvious hazard rule by asserting that a condition was caused by the actions of the defendant and not the condition of the property. So let's talk about that. So as I told you earlier, a premises liability case involves a defect in the premises, that is the land and things permanently attached to it. A claim of ordinary negligence is different. In a claim of ordinary negligence, the plaintiff is asserting that the defendant, through his actions, not the condition of the property, but the defendant through his actions caused or contributed to an accident through his or her negligence. And the key thing to know there is, in those kinds of claims, ordinary negligence, the open and obvious hazard rule does not apply. And so, as you can imagine, plaintiffs want to plead everything as an ordinary negligence claim in order to avoid the open and obvious hazard rule. And they're having difficulty succeeding at that. Why? Because the Court of Appeals has taken the position, look, we don't care what you say in your complaint. We as the court, we're going to look beyond how you phrase your language in the complaint, and we're looking at what is the real gravamen. What are you actually asserting in your lawsuit? And if we find that regardless of your verbiage, that you're actually asserting that the accident was caused by a defect in the premises, then we're going to apply the open and obvious hazard rule. Plaintiffs have had some success in this attempt to plead around the open and obvious rule, but by and large, they do not. In 2017, there were a couple of cases that came along for which the plaintiff had no success. So let me just give you one example. And that is this is the Freeman versus K Mart case. So this was an unpublished decision that came out in 2017. And in that case, one of the K Mart stores in Flint was closing, and they had a closeout sale. And most of the merchandise, by the time the plaintiff fell, most of the merchandise had been sold and removed from the shelves. What existed, however, was an end cap. And so I've given you an example of sort of an end cap here. It's just merchandise that is positioned at the end of an aisle. And what happened is that the plaintiff came along, and in that end cap, it stuck out. This one seems to be tucked back from the shelving, but in the end cap involved in the Freeman case, it stuck out, and as the plaintiff turned the corner, she tripped and fell. So in the Freeman case, the plaintiff alleged that K Mart was negligent not because of the condition of the premises, but based on decisions that they had made regarding the end cap and merchandise. They alleged that once the merchandise was sold off, that the end cap had no further value. It provided no other use, and it should have been removed. That it resulted, because of Kmart's failure to warn of its existence, it resulted in a dangerous condition. Kmart had failed to take steps to make sure that there was a contrast in color between the base of the end cap and the floor, and had failed to inspect the premises to make sure that the conditions were safe. So instead of saying simply that you had an end cap that was dangerous because of its location, that case would have lost immediately. So instead, they tried to think up reasons why Kmart, through its policy and procedures, had failed to eliminate the hazards posed by that end cap. And what the Court of Appeals did, as I've told you in the past, they looked at what the true claim was being made by the plaintiff, and said, look, we don't care what you say in your complaint, you're really alleging that this is a defect in the premises, and premises meaning anything that's permanently attached to the floor, that end cap was, and as a result, you're really asserting a premises claim, and in this case, it was open and obvious. A second case in 2017 involved the same kind of issue, in which a plaintiff's attorney is attempting to plead around the open and obvious hazard rule. The case is called Levatic versus Walmart Stores. In that case, the plaintiff fell on a clothes hanger that was very light in color. It had fallen onto the floor, and the floor itself was a light-colored floor, and the claim was that the plaintiff couldn't see it, and she tripped, fell, and hurt herself quite badly. But of course, the plaintiff's attorney realized in that case that the premises claim posed some risk, and so he or she added an ordinary negligence claim against Walmart as well. And in that case, the plaintiff alleged that the company had a policy, a negligent policy, of overstuffing the clothing racks, and as a result, this caused hangers to fall and accumulate on the floor. They also alleged that Walmart had a policy of understaffing the ladies' apparel department, and as a result, no one was picking up fallen clothes hangers. And lastly, that is in evidence of this, that the hangers had been on the floor a long period of time, and they had some proof allegedly supporting that. But as in the other cases, the Court of Appeals looked to the gravamen of the case. What are you really trying to allege here? And in the conclusion was, look, you're really alleging that there was a defect in the premises, and we're not going to give any credence to this claim of a negligent policy, and instead said we're going to simply apply the standard open and obvious hazard rules to your claim, and in doing so, the case was dismissed. The most common kind of claim that arises out of this area comes in claims involving the negligence in the decisions made concerning the size of gutters, the placement of gutters, whether or not to have gutters at all, and the like. And the claim is, well, because your gutters were too small, or the place that you placed the runoff, it caused ice to form. And that, plaintiffs contend, is an ordinary negligence claim. But those claims have been put to rest once and for all, and those should be dismissed routinely. The case, you'll see them listed in the chapter. The last one was called Eaton, E-A-T-O-N versus Frontier Communications, and similar cases to that. Zimmer versus Harbor Cove on the Lake Condominium Community is a 2017 case that involved the placement of gutters and the location of plowed snow, and attempts to make that a ordinary negligence claim, and it failed as well. All right, so defendants are winning those cases. The last area in 2017 has to do with darkness. And you'll see quite often in any kind of premises claim that the claim is made for falls at night, that the area in which the accident occurred was too dark, and that darkness was the fault of the defendant because of decisions made concerning poor lighting. But what the Court of Appeals has said and has reaffirmed in 2017 is that darkness in and of itself is an open and obvious hazard. And if you have a plaintiff whose claim it is that they were going up some stairs, and because of darkness, in whole or in part, they were not able to see the stairs or some other condition on the stairs or nearby, that the courts are looking to dismiss those cases as well, saying darkness is obvious, and if you enter a room that's dark, then that's on you. And there have been a number of cases, and again, they're listed in our chapter concerning this, including 2017, which the case of Bachrouche, B-A-C-H-R-O-U-C-H-E versus Halawi, H-A-L-A-W-I. It was released in February 2017. The plaintiff fell on ice on a driveway of a residential home. The weather was cold and snowy. The driveway was unlit. And the plaintiff claimed that two things. One, that the driveway was icy, and two, the driveway was unlit and I didn't see it. And therefore, I should be able to get my case to a jury because that condition is not open and obvious. So that's sort of, at the outset they go, well, that's not a bad claim. It's dark. I can't see it. The open and obvious hazard defense requires that the defect be obvious. And if it's dark, it's not obvious, is it? But the Court of Appeals said no. Darkness, all by itself, is an obvious hazard. And if you decided to get out of your car in an area that's dark, where you knew or should have known, a reasonably careful person would have known that you can't see what's on the ground in the wintertime, then there's a fair likelihood that you're going to encounter something dangerous, including a patch of ice. And so, as a result of that, the court had dismissed that case, and then there's a couple of other cases as well that are similar, that are discussed in the chapter. And that's an issue that is often overlooked by claim representatives and, quite frankly, by attorneys too, is that they forget to consider that darkness in and of itself is an obvious condition that can be easily avoided. All right, so that's 2017's highlights. If you have any questions, you can always reach me at the office. My number is 248-851-9500. You can email me at tazoni@secrestwardle.com. Thanks for listening, and see you next year.